Welcome back to my channel. Today is day 12 of the lockdown. I hope you all are doing well. Remember to light the diyas today at 9 p.m. Today I'm going to talk about drafting. Basically, I've been getting a lot of requests on drafting, specifically Supreme Court drafting. I thought I'll make a video discussing a little bit of the nuances as far as drafting is concerned. Now, drafting can be actually two kinds of drafting. It can be that of document drafting, which can be related to, let's say, wills, contracts, SSAs, SHAs, etc. It could be then of pleadings. Now, a little bit I would like to talk about is the document drafting part. So document drafting is primarily something that you would be required to do for, let's say, a company or for an individual. It could be lease agreement, simple lease agreement, simple wills, simple contracts which are there, service agreements, etc. A complex kind of a document could be an SSA or an SHA. In a document drafting, you have to make sure that when you sit with your client, you're able to understand the entire transaction. It is not pertinent that you should be going through each and every clause at the beginning of it. You have to first understand what are the important components or the clauses that the client wishes to add. And then once you've understood the entire transaction, you sit down and start with the document drafting. The clauses which are of utmost importance, you have to add them. Then there will be certain standard clauses that you have to put in. But for any document drafting, you have to understand the law at hand, be it your Contract Act, be it any relevant act, the local act. If, let's say, for example, it's a lease agreement, then you have to ensure that what is the local law looking like, what is the stamp agreement going to be like, or the stamp duty that needs to be paid. So all of that you have to understand. What is the time frame of the agreement, etc. Now, with the document drafting, you have to have a boundary in your head as to how you want to proceed. You can, of course, refer to a lot of templates which are given online. However, it is always advisable to not just copy and paste a certain template which is there, because with each and every contract, the clauses or the recitals may change depending upon the scope of work, depending upon what the transaction is looking like. So therefore, you cannot just think that a copycat agreement can be used. This is the kind of mistake that I've seen that startups actually make. A lot of startups and their owners or the CEOs or the people who just who are the founders, they would go online and just take out a template, and there are so many of these websites which provide you legal templates. However, I personally feel that it is important that you should have your agreements drafted by a lawyer, because if tomorrow there is a challenge that needs to be done, then from a lawyer's perspective, you would always know how the litigation is going to take place and how strong your agreement is. It should not be that it's such a flimsy agreement that, let's say, for example, a simple arbitration clause is missing from an agreement, or in these days we've been seeing force majeure clause being given so much importance. And I know for a fact that over LinkedIn, a lot of people have asked me that their contracts do not have force majeure clause, and how is it that it is going to affect them. So nonetheless, you have remedy available in Indian Contract Act. However, that should have been specified in the agreement. So this is the reason why you need the services of a lawyer, and that is where we all come in. And that when we are drafting an agreement, we should ensure that there is a watertight agreement which has been drafted. Now, when we move on to drafting of the pleadings, it depends upon which jurisdiction or what kind of a draft you are making. For example, if it's a plaint that you are making, it is preferable that you should just make it as concise as possible instead of making it very lengthy. The reason is that then you are spreading yourself thin, and when you are leading your evidence, it is easier to put in your documents or the evidence part, which can then speak volume about your plaint. But when you go into cross-examination, you would see that if you've put in too much in your plaint, it becomes very difficult for you to safeguard yourself, to put in a very good defense there. Also, I believe that when we are drafting, let's say in an appellate side, let's say it's the High Court or the Supreme Court, we have to be very careful about the chronology which is there. List of dates and events is the most important part of it. I have seen in a Supreme Court a lot of time that people basically go ahead and draft a very thin petition, and they do not even bother to annex the relevant documents. There may be just 2 or 3 documents. This basically then hampers your client's interest. Why? Because when you are at the notice stage in Supreme Court, and when you have challenged the High Court's order, then you get about 2-3 minutes actually to put forth your best effort. You have to convince the judge as to why they should be interfering with a well-reasoned order of High Court. And for that, it is important that your synopsis and your list of dates should be so crisp and so thorough that the judge is able to understand the entire matrix of the matter at one shot itself. I have seen so many times that we may not have even argued a matter. It is notice is actually issued on the basis of the petition itself that we filed. So that brings about, that shows a lot of hard work that one puts into as far as drafting is concerned. This reminds me of my own personal experience. When I was starting off in Supreme Court, I was working with an advocate on record who was a standing counsel, and we had a lot of work which would come on the criminal side as well as on the civil and service side. So a lot of times we had to ensure that because of limitation, there were these voluminous lower court details, the trial court details which would have come, and I'm talking about criminal matters here, and you would have your 161 statements, then you would have the entire trial court record, and then with everything, let's say for example Naksha Nazari and medical reports, everything being there. And since the limitation would apply and there would be very little time to get a translation done of such voluminous records and get it back, I remember I used to do the translation then by myself to ensure that we would be able to file everything very quickly. And that kind of gave me an understanding of what the trial court records actually look like as far as criminal matters are concerned. What is the procedure? And so many times I could actually make out as to the cross-examination which was conducted, or the examination in chief which was conducted, or 313 statements of the accused. All of that was the errors in it, or how it was strengthening our case. So all of that kind of came naturally as far as SLP drafting was concerned. When it came to civil appeal drafting, I specifically, our firm was doing a lot of matters from NCLAT, and I realized that insolvency was something which had come in, which was a very new area that we were all exploring at in the first couple of months, and the appeal drafting was a little challenging. But when you know the structure of the appeal, it is not very difficult for you to do a very good drafting. You have to ensure that cases are cited, what we are arguing is very clearly given. A research actually really helps you in terms of when you are trying to strengthen your position. The other, I think, very important part that I would want to cover is that you should understand that you cannot be callous as far as drafting is concerned, because the moment you become callous, you can be doomed. If you are pleading beyond the scope of in your drafting, you have pleaded for things which do not actually form part of the lower court records, in Supreme Court that will not be entertained. So you have to make sure that you're pleading those grounds which have already been taken. And if there are grounds that you feel that have been missed out, then you can always choose to file an additional affidavit where you can bring in additional grounds and facts or place in additional documents. I remember myself that when in the initial years of my career, I used to do drafting for literally pennies. There were big, huge SLPs or civil appeals or writ petitions that I've drafted for next to nothing. However, those draftings and that kind of petitions gave me an understanding about variety of areas, and I believe that if you get an opportunity for drafting or even for appearing, ensure that you do not let that opportunity go, because that is the building block in your career. Also, I feel that there are certain fatal flaws that you have to avoid as far as drafting is concerned. One, you always have to ensure that you are drafting and filing within the limitation. Because if you are not going to be bound by the statute of limitation, then you are doing injustice to your client, and that definitely does not show you in good color. The other thing is that when we are trying to draft a matter, it is important that we know who is the signing authority of the affidavits, etc. A lot of times I've seen that the signing authority is an authorized representative. You require board resolution, etc. And filing can get delayed because the board resolution did not come in time. If there is a delay, a bona fide delay in your matter, then you should specify that in your application for condonation of such delay. Typically, if there is a genuine reason, at least in Supreme Court, they do condone such delays. Ensure that when you're filing, then you also do the refiling within the specified limitation period that has been prescribed. The other important point that I feel is that you should ensure that when you are drafting a matter, you have all the documents which are pertinent to the matter with you. If you are going back and forth with the client for the documents, then the drafting gets delayed, as a result of which you may be sitting and start doing a drafting, and then you realize, oh my god, this document is missing, and then the document actually comes after a week. So you have the entire train of thought has actually derailed then, and then you are not able to do justice, because you have to go back with whenever that document comes, and you are then going back to starting with the drafting again. You might not remember all the points that you would have wanted or how you would have wanted to draft it. If you have the resources, then, or if you can request a senior, then you must always get your or a colleague, you must always get your draft checked, because then you would know the flaws in your draft, and that will always be very helpful for you to grow. The other advice that I would like to give you is that you must read the commentaries on a specific law that you are trying to make a pleading on. You have to understand what is the remedy that you are seeking, what is the fact of the case looking like, and whether or not that when you are filing a matter, the court or the forum actually has jurisdiction. A lot of times I've seen that the matter gets dismissed in limine only because the jurisdiction of the court did not apply. These are, I think, very simple things which you can use in order to avoid inconvenience to your clients. The other thing is that you should always have a checklist in place. Checklist because a lot of times when you are doing filing, you have to know whether all the documents are available to you or not. For example, if there is a petition you're filing and there is a stay application that needs to go, ensure that you file it along with the petition. Or if there is an application for condonation of delay that needs to go, or there is an application for exemption from filing original translations, all the likes, maybe it is an IA which you have to move. Ensure that all of this gets filed at the time of filing only, and therefore drafted in totality. So that gives you And so the flow of the petition or the pleadings actually is maintained that way. Commentaries, I think, is very important, so you must ensure that you are reading the commentaries, because that gives you a very good understanding. For example, if you're reading R&D, so that really will help you as far as CRPC or IPC matters are concerned. It gives you a very clear understanding as far as criminal matters are concerned. So that's about it from me today. I hope you enjoyed it. If there are specific queries, you can always ask me in the link below or in the comment box. You can write to me, and please do like my video and subscribe to my channel. If you like it, do share it also. Take care, and I shall see you tomorrow.